Welcome to the FedLife podcast with Dan Sipe from Serving Those Who Serve. In this podcast, Dan draws from years of financial experience to help federal employees overcome challenges that every Fed can relate to. Join us for this journey as we reach, teach, and serve to help you make the right financial decisions. Now, on to the show.
Hello and welcome to this episode of the FedLife podcast. I'm your host, Dan Sipe. Additionally, as you all know, I'm the branch manager here at Lee Sipe and Associates and Serving Those Who Serve. And as I always do, I want to open by saying thank you for listening, and above all, thank you for your service. You simply do not hear that enough, and you will always hear it here. We're back again today with the guru, the incomparable, the amazing Ed Zurndorfer, as part of our ongoing mission to reach, teach, and serve you. And these are strange times. We are coming up with different ways. Ed is writing furiously. We're kicking out posts as fast as we can. Ed and I are going to be back channeling after this, talking about ways that we may be able to reach out to you folks virtually with some of that amazing Ed Zurndorfer live content. We are here in this with you, and we are doing our level best to get you what you need while you need it. It is my sincere hope that everybody that might be listening and all of your friends and family are safe and well. That is the most important thing right now. Everything else we can sort out. Retirement dates can move. We can do whatever we need to do if we get through this, and we will. At the outset, I need to say the opinions of our guest, Ed Zurndorfer, no matter how amazing they may be, are not the opinions of Raymond James or Serving Those Who Serve. This podcast is presented for information only, not intended to be taken as advice. All listeners should consult their personal advisors before taking any action. Okay, by now, we're pretty well in, probably about a month, depending upon where you live within earshot of this, of shelter-in-place orders, things like that. And we're getting used to, little by little, to the new normal. And one of the things that passed Congress that has been designed to help is something called the CARES Act, C-A-R-E-S, which stands for Coronavirus Aid, Relief, and Economic Securities Act. Now, quite frankly, I have seen where they have worked super, super hard to come up with acronyms. And in this case, you know, it just seems to fall together beautifully. And the president signed that into law on March 27th. There are quite a few provisions in this act. So we really are lucky that we have Ed with us today to explain it in people speak for the rest of us, how the CARES Act will affect feds. And so, again, want to stress, anything we cover here meant for education, information, not meant to be taken as advice. Consult your person. So, Ed, with that in mind, would you list for us the features of the CARES Act, and then we'll break them down individually? Okay, Dan. The CARES Act, as you mentioned, was passed on March 27th after President Trump signed it. And it has the following provisions. One, there is a qualified retirement plan loan expansion. What I mean by qualified retirement plan, for example, a 401k or 403b is a defined contribution plan. The thrift savings plan is a defined contribution plan. However, it is not considered to be a qualified plan. It has many of the features of a qualified retirement plan. So it is included in this provision that individuals can expand, if they have to, they can borrow against their retirement plan in greater amounts, and they have more opportunities to pay it back without penalty. Also included with the CARES Act is the qualified retirement plan hardship distribution rules were modified to make it easier to take out a hardship distribution from your qualified retirement plan. Another feature, which affects mainly people over the age of 70, although there are people younger than 70 who are going to be affected by this, is that for the year 2020, any required minimum distributions that had to be taken out from a qualified retirement plan or from an inherited IRA are suspended. During the year 2020, no one has to take out what's called an RMD from their
retirement plan or IRA. They are suspended for all of 2020. And one other feature is that the employer-provided tuition reimbursement program, although it has nothing to do with retirement, was expanded so that employers can now pay for more of an employee's tuition and fees if they go back to school, take some courses. They can pay for fees, books, and other supplies with no tax consequences.
Wow.
And the program was expanded just for this year, 2020. So those are the key features of the CARES Act.
Okay. And folks, it may go without saying, but we're going to touch on this. Ed and I are sheltering in place. We are not crammed in a little studio like we usually are. We're following all the guidelines. Ed, you and yours are safe and healthy, right?
Absolutely. We're here in the office, and my employee, who happens to be my wife, we're an administrative assistant. We're here working in the office. Most of the time, we are at least 6 feet apart.
Gotcha. Well, that's wild because my wife is my boss, so I'll be real interested in hearing how you work that out. Okay, so to dive back in, and one of the things I want to stress, just like always, if you're listening to this, ordinarily I'd say if you're commuting, nobody's really commuting that much anymore. But if you're listening to this while you're doing something else, you've got your earbuds in, listening to us, and I don't really have the ability to write something down. Don't worry, because all of this is also going to be published on the SCW Serve website at blog.scwserve.com. You can read Ed every week. So Ed, let's flip this a little bit. And let's begin with the last feature you mentioned, the expansion of the employer-provided tuition reimbursement program. That seems to have the fewest moving parts, and then we can work up to some of the more complicated provisions. I don't think a lot of people know about this, so Ed, why don't you touch on that a little bit?
Well, Dan, this is the tuition reimbursement program has been around for a while. It allows employers to pay for an employee's tuition, fees, books, and other supplies. Up to $5,250 can be paid by the employer to the employee, tax-free. There's no tax consequences. But for 2020, the key feature is the fact that it is tax-free. And in my opinion, the most important thing is that if the employee is going back to school and has to borrow to go to school, they don't have to borrow. They can use the money from the employer to pay their tuition and fees.
Sure.
And they're really saving that money. They're saving that money they have to pay for the lender. They have to pay if they have to go out and get a loan. And instead, this is important, especially for the younger people, they can put that money they would normally pay the lender, they can contribute to the TSP if they're a federal employee.
Oh.
Again, I find that anybody who plans who wants to go back to school, I don't know if they can physically go to school, but they can take online courses, improve their performance, things like that, can take some courses between now and the end of the year and use that money from their employer to their agency, let's say, to pay for the course, any books, any supplies, and then the money they're saving, use it to put money into the TSP.
Sure, because one of the things, and we'll touch on this as in our next podcast, but federal employees have a pretty good advantage right here in the fact that pretty much they're all still working. Anybody in that situation, we got to consider them to be lucky and blessed right now. So that seems like a really good provision for newer feds or feds of any age to take advantage of. Let's take a look at the Qualified Retirement Plan loan expansion feature and how that might provide relief.
Well, Dan, I have to emphasize that a qualified retirement plan, and as I mentioned, this would include also the TSP, does not have to provide this benefit. If they don't want to expand their loan, the amount of loans that an individual can take out, they don't have to.
Okay.
And the TSP, I want to mention, has not made any modifications to their rules. Okay. Let me just mention what the amount that an individual can borrow against their TSP. The limit is the lesser of $50,000, or the lesser of $50,000 or their account balance. They can't borrow more than that. That's the current rules. Under the CARES Act, it doubles to $100,000.
Okay.
Of course, if a person has any other loans out there against their retirement, that $100,000 limit is going to be reduced by the amount of any outstanding loans. But the TSB has not modified the $50,000 limit. It's still $50,000. It has not gone up to $100,000.
Okay.
And be honest with you, Dan, I don't think they will, because if they haven't done it till now, I don't think they will. And we have to keep in mind that this is mainly for people who are not working. They've lost their job.
Yep.
They're not getting paychecks. Federal employees, thank goodness, are still getting their paychecks. They don't have to go out and borrow against their TSP to pay their bills.
I'm with you on that, Ed. But we remember within the last year or so, we had a little thing called the shutdown. So, I think this is a little bit of fair play now that our feds are in a little better position. But I agree with you. I agree with you on that.
Well, we're going to talk more about that later, about some of the do's and don'ts about in case people lose their jobs. And federal employees some employees lost their jobs in 2019. Well, I shouldn't say lost their jobs. They weren't being paid, and taking out TSP loans or hardship withdrawals was not a good idea. But anyhow, we'll talk about that later. But again, just want to make the point now that TSP has not made any modifications to their loan provisions.
Okay.
Nor have they made any modifications to their hardship distribution rules, which we'll talk about next.
But I think the important thing here to touch on, and I know you've encountered it in your practice, we've certainly encountered it in our service to feds, we have a lot of blended families where we have folks that one works for the Fed and one doesn't. So we could have some families out there that are touched by this, where one of the family members is out of work, and therefore knowing about this could be a big help to them.
Good point. There are many blended families, so to speak, and the fact that the one spouse, in fact, may not be working, and the family is having a tough time paying its bills. So therefore, the family member who is the spouse who's not working, let's say, may want to resort to a qualified retirement plan loan or a hardship distribution to help pay the bills.
Right. Now, up next, let's talk about the change to the hardship distribution rule. And for starters, why don't you run through what a hardship distribution is and how you can be qualified before we jump into how the CARES Act changed it?
Okay. Normally, an individual cannot really take distributions from their qualified retirement plan until they reach a certain age, namely, in the case of, let's say, a 401k, 403b, or the TSP, it's normally age 55. If they retire sometime during or after the year they turn 55, they can, without penalty, start withdrawing their money from their retirement plan. They have to pay tax, federal, and in many cases state tax, but no early withdrawal penalty. With a hardship withdrawal, an individual who is younger than 55 wants to take money out of their qualified retirement plan, will pay federal and state tax on the amount withdrawn and a 10% early withdrawal penalty because they're under 59 and a half in this case. Mm-hmm. Now, the idea between the difference between the hardship withdrawal and the loan is that with a retirement plan or qualified retirement plan loan, the money is going to be paid back with interest. But with a hardship withdrawal, the money is not going to be paid back. It's out, it stays out, it's not going to be put back. Gotcha. Under the CARES Act, the retirement plan accountants will pay the taxes due, the federal tax due on the amount withdrawn. The 10% early withdrawal penalty would not be the case. There would be no 10% early withdrawal penalty. But there's another good feature about the CARES Act, CARES Act modification with a hardship withdrawal. The individual can actually pay back the money withdrawn and do it over the next 3 years. They can pay it back. They can pay it back not only to let's say to their 401k, to their 403b plan, but they can actually pay it back to an IRA. They don't have to pay it back to their plan.
Really?
And if they do, they won't have to pay tax on the amount withdrawn. If they pay it back within the next 3 years, they have a 3-year period to pay back the money they took out, and this way they will not have to pay tax on the amount taken out as a result of the hardship withdrawal. But in order to qualify for the hardship withdrawal, there are certain requirements. The retirement plan owner or his or her spouse or dependent must have been diagnosed with a coronavirus or lost income as a result of a layoff, business closure, reduction in work hours, or inability to work due to a lack of child care. So let's go back to our blended family here. We have one spouse who's a federal employee getting paid, one spouse who works in private industry, and has lost his or her job.
Right.
And family has to pay their bills. They have no other means. So the spouse who lost his or her job will go into their 401k, take a hardship withdrawal, takes the money out, and then has every intention to pay it back within the next 3 years. There's no 10% early withdrawal penalty. In that sense, everybody is very happy because the only thing that's going to be lost by the person who took the hardship withdrawal is that any earnings on the money that the person would have gotten had the money stayed in the retirement plan are permanently lost. But at least they don't have to pay a penalty, a 10% early withdrawal penalty. I want to emphasize that the qualified plan retirement distributions apply only to distributions to eligible individuals, and the money has to be taken out between January 1st, 2020, and December 31st, 2020. Okay. Again, if someone's going to do this, they have to do it before the end of the year.
Gotcha. Again, you hit it with blended families, things like that. This really could be a significant feature for a lot of people to get through this. And I think that's the biggest thing. We see it in the media and we share it with one another. You know, we're going to get through this. This is one of those things that helps define a generation. It's going to define multiple generations within my own household. So absolutely. So let's go to the last provision, Ed, which is changes to the required minimum distribution rules for 2020. On the surface, you know, people might recognize that as saying, well, gee, you know, I'm not that old, I'm not doing that yet. But this could actually affect some working feds if they've inherited an IRA, could it not?
Absolutely. As I mentioned a few moments ago, Dan, the RMD rules are being suspended for people who must take RMDs because they're over 70 and a half. They were born before July 1st, 1949, and they are retired from the federal service. They got to take a TSP RMD, or they retired from private industry, and they're over 70 and a half. They have a 401k plan, or anybody who has a traditional IRA who's over 70 and a half has to take an RMD this year. But it also is normally taking RMDs. But anybody who inherited an IRA, let's say, from a relative, such as a parent or a sibling, and it could be a traditional IRA or it could be even a Roth IRA. The Roth IRAs are subject to RMDs if they're inherited from non-spouses. So anybody who inherited an IRA, someone who passed away before January 1st, 2020, is required to take an RMD. The general rule has always been that the money that cannot stay in this inherited IRA indefinitely has to be taken out. It could be paid out over the person's life, the beneficiary's life expectancy. But effective with the Secure Act, those rules have changed. We'll talk more about that in a few moments. But the fact is that anybody who inherited an IRA before January 1st, 2020, from a deceased relative, a non-spouse, is required to take RMD, no matter what their age is. That being said, if their RMD, if they have an RMD coming due, anybody having an RMD coming due in 2020 is not required to take their RMD in 2020. They can skip it. This is a big relief to a lot of people.
Sure, I can
because
I can see that.
I get many questions about those RMDs from all types of individuals, and I have to emphasize the point, Dan, that the IRS has some very strict rules about taking your RMD. There's a penalty for not taking your RMD in any given year, and that's a 50% penalty, 50. If you didn't take out, let's say, suppose you had an RMD, let's say, of $5,000. You were supposed to take $5,000 from your retirement account or your traditional IRA, and you didn't do it. IRS is going to give you a bill of $2,500 because you didn't take out the $5,000.
Ouch.
But for this year, no penalties because there are no RMD. There are no RMDs.
Okay, well, let's, and folks, if you're listening to this and you know somebody who's retired and you want to share this with them, please feel free to do so. Share the link, because I'm going to ask a question. Let's talk about somebody who's already retired, because, we help feds at every stage, right, Ed? We're talking to folks who are retired. We'll help them too. And so if somebody's already retired and took their RMD and now knows that they might not want to do that, you wrote a follow-up article on this. What are their options?
Well, in the case of let's say we take a federal annuitant, Dan, someone who has a TSP account, and they're over 70 and a half. They're over 70 and a half. I know several people who like to take their RMDs as early in the year as possible. Why? Because this way they won't forget to take. They get it over with right away. But I got to be very honest with you, Dan. The TSP, among its good features, is the fact that no one who has a TSP account will ever pay a 50% penalty to the IRS.
That's right.
The reason I say that is every January the TSP sends a notice to anybody who is retired from federal service over age 70 and a half who has a TSP account, and in that notice, the TSP says to the person, you are over 70 and a half, you're retired, you are required this year to take out X number of dollars from your TSP account because that's your RMD. And the person sees it and says, okay, I'll start taking it out. So I'll do it in a few months. I'll take out the money. I'll be sure to do it. I'll be good about it. But then they forget about it, and they forget about it, and they forget about it. But come probably between December 1st and December 15th every year, something is going to show up in that person's bank account. It'll be a check from the TSP for their RMD, because the TSP will automatically send the RMD for the year to the person in December if they don't take it out. The TSP is not going to do that this year because the TSP knows, and they put on their website that they're not going to. No TSP participant is subject to the RMD for 2020. They know that. However, let's get back to that person who got that notice in January about their RMD, for the year 2020. So, I got to do this right away. I'm not going to wait. I'll forget. I'll do it. So let's say on February 25th, that person decided, I'm going to take out my RMD right now. On February, let's make it February 25th, 2020. They did their RMD for the year. They got it over with. They're very happy. Okay.
Yep.
Well, on March 27th, the president signed the CARES Act. And as a result, as we mentioned, RMDs were suspended for the year. But this person already took their RMD. So now what happens? And when I say they took their RMD, keep in mind, Dan, that the TSP will send the RMD to the individual, direct deposit in the bank, or send them a check. But they also take out usually 10% in federal income taxes.
Sure.
If it's a traditional TSP, it's all taxable. They'll take out 10%, more if the person had requested, but normally a minimum of 10% federal income taxes. The money's out, but the person didn't have to take it. Now what? Now what? They took out the money. They didn't have to. Is there any recourse? Can that person put that RMD back into the TSP?
I hope the answer is yes, Ed.
The answer is April 21st. April 21st. Okay. It's 2 months after the fact. Can they put it back? No, actually, the answer is no. They can't put it back. They can't put it back into the TSP. Is there anything the person can do?
Well, would they be able to take care of the 60-day rollover period?
Well, there is a provision in the Internal Revenue Code that allows someone who took a distribution from a qualified retirement plan, also the TSP, that if they took the money out, they can roll it over into a traditional IRA, provided it's rolled over, it's put into the IRA within 60 days from the time they got the distribution from the qualified retirement plan, or in this case, the TSP. So let's go back to our example. What day did we say the person took the money out? February 25th?
Yep.
Let's see. We got how many? There were 29 days in February, so that's 5. That's 4 days plus 31 days in March is what, 35. Mm-hmm. Plus 25 days into April, that makes it April 25th. That person could take the money that they received from the TSP on February 25th, but you got to keep in mind that the 10% was held with federal taxes. If their RMD, let's say, was $6,000,
yep,
10% or $600 was held for federal, so they actually received $5,400, but they still would have to deposit into a traditional IRA, a rollover traditional IRA, the full $6,000 no later than April 25th, 2020. By my watch, that's about 4 days away, right, Dan?
Yep, they got to get moving.
And if they do, they put the money, the entire $6,000, into the traditional IRA. Then, when they file their 2020 income taxes next spring, the TSP will issue that person a 1099-R, which is a distribution form. But in box number 7, there's a code that tells you what type of distribution it was. Normally, if it's a distribution, a normal distribution, it's a code 7. But it was not a normal distribution because the person rolled over. There'll be a code G, which stands for rollover. Rollover, which means that it's not going to be taxable. The person files his or her taxes and will get a refund of the $600 that was withheld for federal income taxes. But I got to emphasize, it is a very strict 60-day deadline. You blow the 60 days, you're going to blow the whole thing.
Gotcha. Okay, so that's good information and a good warning to be specific about it. Now, a question that you touched on earlier, and we're kind of looping back to because when you wrote one of your follow-up pieces having to do with the CARES Act, there's only one of those 60-day rollover periods for every 12-month period, correct?
That is correct. The IRS has a rule that you're only allowed to do one 60-day rollover per 365 days. So
gotcha.
if you did the one now, if you did the one rollover now, you did it within 60 days, and let's say for some reason you had another RMD. Let's suppose you had the person over this example is over 70.5, also has a traditional IRA, and for some reason they took out an RMD in early March from the IRA, and they want to do a rollover. They can't because
gotcha.
They already used up their one rollover for the 365-day period. So they're sort of going to have to be stuck with that RMD. They can't get them. They cannot get the money put back into the IRA.
Gotcha. And last thing to kind of round us out for today, in a previous FedZone column, you explained the Secure Act. And could you just refresh everybody on that 10-year rule for the required minimum distributions now? Because as you mentioned earlier, there's for one group who inherited before this year, say with beneficiary IRAs, they've got their lifetime to do it. But somebody who inherits this year will have 10 years, and someone who begins their RMDs, after age 70 or who gets an inherited IRA is going to still have RMDs to come out, but they got to get it done in 10 years. Would you touch on that?
Yes, under the Secure Act, anybody who inherits a traditional IRA, Roth IRA, and this is what's called unless they're a special type of beneficiary, someone who's disabled, but someone who's other than they're disabled or not a child, just a child, or someone who's more than there's more than a 10-year age difference, something like that. Just someone, just a regular beneficiary. Then under the Secure Act, if they inherit an IRA from a parent, then they're going to have 10 years in which to have that account cleaned out. Withdrawn. They had to withdraw within 10 years. They used to be able to take over the life expectancy. That's gone. They have to take the money out of the account within 10 years. They don't have to take an amount out each year, or an RMD each year. But after 10 years, if they haven't, let's say, haven't taken anything, they have to take out the entire amount that's left over to 10 years. Here's the point, Dan. Effective January 1st, 2020. The 10-year period is going to be in effect. Anybody who died after December 31st, 1999, who bequests their IRA to a let's say a regular beneficiary, not one of the exceptions, that beneficiary has to have the money paid out to them within 10 years of the death of the person who gave it to them. And I have an example. If somebody died, let's say on January 2nd, 2020, and let's say they're the beneficiary of the IRA, mom died, and names her son as beneficiary. The son has until January 2nd, 2030 to have the account cleaned out. Well, under the CARES Act, the year 2020 doesn't count. The person gets an extra year because the meter starts as of January 2nd, 2021. So the person has to have it cleaned out as of January 2nd, 2031, not 2030. So they get the extra year. Gotcha.
Well, Ed, once again, an incredible amount of information that you had for us today, and you broke it down so regular folks like me and everybody else can follow and understand, so that's great stuff. Folks, that's a wrap. Ed will be back. We're going to be talking about Social Security survivor benefits in our next podcast, and also some of the things that you may want to be thinking about relative to as you're working your way through the COVID-19 crisis. And he will be with us in our efforts to reach, teach, and serve you. We are serving those who serve. Be sure to subscribe to our podcast on our YouTube channel, also on Spotify. And remember to share it with your friends and strangers. Check us out on Twitter and LinkedIn. Stand by for more information about our educational outreach as we comply with the various stay-at-home orders around the DMV. Our live seminars with Ed are suspended. We will be back. I promise you that. But we're producing even more content. Ed is pushing columns out weekly, and we have additional content going in there. Again, that's at blog, B-L-O-G, at stwserve.com. And we're going to keep working feverishly with Ed to bring great content to you via the web. Watch our social media posts, emails, and websites for more on that. Be sure to read Ed every single week in the Fed Zone. Again, blog.stwserve.com or at fed-zone.com. So for Ed, the crew is serving those who serve, and me, Dan Sipe, good luck, Godspeed, stay home, be safe. And above all, remember, it's your FedLife. Protect it right now and make it a great one because you deserve it. Stay well, everybody. We are out.
Thank you for listening to the FedLife Podcast. Click the subscribe button below to be notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Serving Those Who Serve or Raymond James. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning. Securities offered through Raymond James Financial Services Incorporated, member FINRA SIPC. Investment advisory services offered through Raymond James Financial Services Advisors Incorporated. Serving Those Who Serve is not a registered broker-dealer and is independent of Raymond James Financial Services.
Raymond James is not affiliated and does not endorse the opinions or services of any of the quoted professionals or their respective firms. Any opinions are those of Dan Sipe and not necessarily those of RJFS or Raymond James. This case study is for illustrative purposes only. Individual cases will vary.
Neither Raymond James Financial Services nor any Raymond James financial advisor renders advice on tax issues. These matters should be discussed with the appropriate professional. Investing involves risk, and you may incur a profit or loss regardless of strategy selected, including diversification and asset allocation.
Raymond James is not affiliated with and does not endorse the opinions or services of the quoted professionals or their respective organizations.